Struggling to pay your child support? Are not receiving any? Need a modification? Has the Department of Revenue filed a case against you? Don't face this alone. If you are dealing with a child support problem, a knowledgeable family law attorney may be able to help you solve it. Let us help so you can focus on being the best parent you can be. Stress less. Choose more.
Good afternoon, everyone. My name is Conti Moore-Smith, and I am excited to be here with my favorite board-certified immigration attorney, Frank. Frank, do you want to introduce yourself?
Thank you, Conti. Yeah, my name is Frank Symphorien. I'm a board-certified immigration expert and founder of Symphorien-Saavedra Law, and privileged to be here with you, Conti, my favorite family law attorney in the state.
I appreciate that. And I appreciate you taking the time every month to answer questions. We get a lot of calls with people that are dealing with family law, divorces, and they have immigration questions. So I appreciate you taking your time to come here every month to help answer some of the questions that we get from some of our callers.
Appreciate you having me.
So let's get into it. All right, the first question: what is an affidavit of support, and does divorce end that obligation?
So this is kind of a timely topic. You may not have been aware of this, Conti, but over the past maybe couple of weeks, the Department of Homeland Security published they revoked an old Biden rule so basically when you're filing for residency status in the United States, you have to prove that you're not likely to become a public charge. Anybody who wants to become a permanent resident, then later on citizen, has to first prove that if they become a permanent resident, they're not likely to depend on the government or become a public charge for whatever government services, etc.
Hold on, just so people can follow. That means that you won't need to get support from the government, right? Like, is that what it's like?
Exactly. Yeah, you have to prove that you're not going to need government support. You're not going to go to Medicaid, food stamps, things like that. You have to prove that you're not likely to require government assistance.
Okay.
And so one of the ways that you overcome that bar to becoming a resident is by having a U.S. citizen who has sufficient income to sign an affidavit of support. And in filing that affidavit of support, that person basically makes himself responsible to maintain and support you at minimum to 125% of the poverty guidelines, right? So I think something like $20,000, $22,000 for a couple of two people. The challenge with that is that the way that document is written is that it's supposed to, you can't terminate it based through divorce. And obviously you can talk a little bit more about that, Conti. But in general, the way that the form itself and the federal regulations are structured, they're supposed to can only be extinguished through death of the petitioner, the person, the U.S. citizen, the immigrant becomes a permanent a citizen, or gets over 40 credits of Social Security work history. And so unfortunately, there is some small arguments. There's some case law being challenged in federal court to try to open that, arguing that only the government is a third-party beneficiary of that argument and that the spouse cannot benefit from it. But the courts are not always catching on to that. So for the most part, the government can go after you, the sponsor who signs the affidavit, if you don't support the immigrant.
So where I'm seeing that come up a lot, Frank, is that people are calling us. They're going through the immigration partner or the process with their spouse, and now they want a divorce, and they're like, "Well, I signed this affidavit. Am I still on the hook?" And I'm like, "Oh, that affidavit is separate and apart from the divorce. Like that, we're going to deal with the assets and liabilities that were acquired during the marriage, and we'll deal with that. But the court doesn't have jurisdiction or can't really do anything over this agreement you signed, basically with the federal government, to support this person. Like it's two separate issues."
Right. Well, I guess that's part of the argument too, Conti, that's being developed I think it's in the U.S. District Court in Southern District of Florida. So historically was sort of treated as separate. And if the immigrant wants to sue you separately in district court to enforce that support obligation, I know that there's a couple of lawyers out there that will do that. The immigrant claims, I need help, I need support, I I don't have the minimum income to the poverty level, they can't file that. They have filed that type of lawsuit in federal court. What the defenses have been raised recently is that the federal courts don't have jurisdiction, and this is complicated legal jargon, but as part of the Constitution, because divorce and family ties are historically a state issue. And so that's been part of the defense, in that the federal government and the federal court can't get involved in family issues and enforce those support obligations.
Now, that's interesting. Keep me posted on that. But right now, what I'm saying is correct, right? It's separate.
It is correct. And that's been longstanding, understanding that it's a separate issue, that it can be enforced even after divorce in a separate proceeding. The government is a beneficiary. That's so the government can sue you, or the immigrant can sue you. But again, the development is that not against the government, but development has been against immigrants who have tried to enforce this. And there are some defense attorneys that are making arguments that can't be done in federal court, that it has to be brought in state court, and that, and trying to get these cases dismissed.
Interesting. Okay, well, keep us posted on that and what happens with that, because that will impact a lot of people. All right.
Sure.
Can a sponsored immigrant sue their former spouse for financial support?
So I think we covered it a little bit, right? That's the same question we just discussed. The answer is yes. They can sue their former spouse for support. Where they do so is what's a question, right? Can they do it in federal court? Can they do it in state? It's your understanding and my understanding as well that it's not part of the divorce proceeding,
right?
And that the state court wouldn't look at that. So usually it's been a separate proceeding in federal court. But again, there may be some defenses to that. And you want to contact Conti, and we'll get you some additional resources at future lives to talk a little bit more about that if you want to defend yourself against that support obligation.
Okay. All right. And how long does a sponsor remain financially responsible after divorce? I want to make sure we're clear. I know we keep asking the same question, but I want to make sure that everyone's clear on it. So currently, right now, based on the law as it stands,
right,
how long does a sponsor remain financially responsible after a divorce?
So the terms of the agreement that you sign in the support itself and in the federal regulation state that support will only end if you become a citizen as the immigrant. If the immigrant becomes a citizen, if they get at least 40 credits of Social Security work history, which typically you earn about 4 per year. So it would usually be around 10 years is when, if the person works, right? If they don't work, they won't get those credits. Or obviously if the petitioner or the beneficiary dies, right? Those are the only two ways that the support obligation ends. So you can't, I guess the decedents, like if the immigrant's children probably can't, sue after the immigrant dies for support that was owed to their parent, right? Something like that. So those are the principal ways.
So when you sign up to be a sponsor, it's a long-term commitment, basically.
Okay. I tell people it's like signing a co-signing agreement, and there's some conflicts involved because I don't even get involved when my clients have this, because if there's a co-sponsor, usually, it's a serious legal commitment.
All right. Now, does signing immigration sponsorship documents affect alimony negotiations?
I think that's a good question for you, Conti. I'm not sure.
No. That's a separate issue, right? So that's a separate issue that I think is with the government. But as far as when we look at alimony and what the court's looking at, they're looking at what one person's need is and the other person's ability to pay. So it's an analysis that there's several factors that we go through in order to figure out what alimony should be. But the first step is, does one person have a need? Does the other person have the ability to pay? And then we go and we look at what's the net income. So if you have one person and their net income is $100,000, and then the other spouse, say their net income is 0, the court's going to say, okay, so what's 100,000 minus 0? That's 100,000, and your best day in court would be 35% of the difference. So that would be $35,000 per year annually to help figure out the alimony for that case. Now, what matters is how long is the marriage? So if it's under 10 years, then you can get that amount for up to 50% of the duration of the marriage. If you're married between 10 and 20 years, you can get it for up to 60% of the duration of the marriage. And if you're married for over 20 years, then you can get that amount for up to 75% of the duration of the marriage. We just got a calculation 3 years ago. I believe it was July 1, 2023, when we actually Florida adopted or basically had a calculation for alimony. Before it's kind of like a free for all, but now we have that formula. So that like we're not looking at what you could be ordered to pay under another agreement. We're looking at income. What's the net income? What's the difference? What's that person's need? Does that person have an ability to pay? And we're calculating it from there. So in the agreement, it's an agreement, right? So what they're signing for the sponsorship document is just an agreement to help cover their expenses if they need them. Is that right, Frank?
Yeah, that's correct. Yeah, correct.
So that's different from a court-ordered agreement to pay a certain amount of money for alimony or child support. You know, I don't believe the agreement says anywhere, correct me if I'm wrong, you need to pay this amount of money per month to this person, right?
So it is, because it's 125% of the poverty guideline. So the immigrant under the agreement is entitled to that sum, and the federal poverty guidelines are published every year. Like I said, right now it's like 22,000 for like a family of two. And so for an individual, it might be like something like 15,000. Don't quote me on that, because they're published every year. So arguably under the federal guidelines, you would be expected, if the immigrant says, I don't have enough money, I need help, and they file a lawsuit against you, arguably the federal court could order you to pay, that $15,000 a year to keep that person at minimum. Now, there's arguments that it could be offsets for their ability to work or any income they have, et cetera. But if the person says, I have no job, I can't get a job, I can't work, et cetera, then arguably, you'd have to pay that full amount.
But it doesn't say that you have to give them the money on the first of the month, this amount, the first of every month. It's just saying what your obligation could be.
Correct.
Right?
That's right.
In the event that they enforced that the contract that you signed.
That's right.
So that's still at this point separate and apart from, hey, this is what your need is. This is this person's ability to pay. It may be best for practitioners to say this, that this alimony amount exceeds what's required under the agreement that they signed.
Right.
For that's a great practice point that we should incorporate as family law attorneys,
Right.
to include some of that language. But it's a separate analysis, right? Like what you agreed to just when you sponsored that person versus what you may have to pay. It could be a lot more money in alimony based on your income, right? That you may be obligated, that you may have to pay under the statute for alimony here in Florida.
And I think that's the big thing with having competent family law attorney like Conti, and she's just a delight to work with, because we can have these brainstorming ideas and we can develop theories, et cetera, on how to, and one of the great things that I think your firm has been kind of pioneering and at the forefront of out there in the field is trying to see prospectively, right? Right now, that's not necessarily the law. It's a separate proceeding, but if you can get it in there, and you can settle any state claim in regards to the affidavit of support through the alimony negotiation, then if the dam breaks through in these district court arguments that are being made that, hey, you can't file in federal court, it has to be done in state court. Well, if you already had a state court proceeding and you agreed to give up that support obligation, then potentially, you're golden there. And that's where, Conti's is so great. Her firm is so great at looking prospectively at those potential issues and trying to resolve them now rather than later.
No, I appreciate that. But what's also important is that not every family law attorney is an immigration attorney, right? And so like I tell everybody that you can't be great at every single thing, right? So you want to get with whomever you hire, if they're not an immigration expert like Frank is, they need to go and talk to someone about the implications of what they're doing, what could happen, right? Because you can't be a jack of all trades.
There's no trade master of none, right? I mean, if you're really, and it's interesting because you see lawyers out there, and I tell, look, I'm pretty sure like the Florida bar and everybody went to law school, and we're two of the smartest people in the state. And when I see lawyers that say I do everything, I'm like, man, am I dumb or something? But I know I'm not. Everybody says I'm not, because you cannot be good at everything. You can't be the best at everything. Okay. So the issue is that if you're doing everything, family, criminal and immigration, especially immigration right now, as complicated as it is, and the risk involved, because the government's just being very aggressive. You're really putting yourself at risk, because, that means you're probably average or below average at everything that you're doing, right? You just can't, it's impossible to know everything.
And we talk every month about the updates, and I'm still like, okay, we'll check with we'll have to do a consultation with Frank about this, because I don't want to tell anybody wrong, and I don't want my team to give wrong advice. So it's really important for those people who are watching to understand that you need to get someone who's actually doing this and answering the questions to give you advice on it, versus someone who's kind of dibbling and dabbling in it. So
court every day like you do. You're in state court every day. You're going to these settlement negotiations. You're doing the work with the judges. The judges. I was talking to somebody who wants to hire me to go to New York, and the home court advantage is a big thing. It's a real thing. Conti knows the judges. She's helped some of the judges get elected. She's just a power player in the Orlando, Central Florida community, and so hiring her is a huge deal. And same thing for immigration. I go to immigration court. I clerk there. I know the judges. I'm friends with all of them. There is a big thing with state court, home field advantage, as well as being an expert in the field. Because, even if you're in Orlando, but you go to court once every 6 months, because you take one family court case once every 6 months, that's just not going to cut it.
No, I agree. So you want to make sure that whoever you deal with, if you're not dealing with us, that they are going to people who actually specialize and who actually deal in that area to get advice, especially when it comes to immigration and family law. So next question. And this one's going to be more for you. So I guess both of us, can a stepchild still receive immigration benefits after a divorce? So I'm assuming that the one of the parents or somebody sponsored the stepchild, and so
right. So usually would be the stepchild is an immigrant, and the spouse isn't, the parent, the blood parent, right, is an immigrant, and so usually the U.S. citizen can sponsor the stepchild if the relationship with the mother of the stepchild was created before the child turned 18. That's a critical requirement. So it's not forever. It's not after 21. The relationship between the parents has to have occurred before the child turned 18. If that is the case, then the answer is yes, as long as the stepchild and the step-parent continue to maintain a stepchild-stepdaughter relationship. So they can't just, okay, we're a stepchild, we don't talk, we're not involved in life anymore, and then you call them 6 years later out of the blue, hey, can you sponsor me? That won't work. There has to be a continuing step-parent, stepchild relationship, but it can be done.
Oh, okay. Well, that's good to know. All right. What happens if a child ages out while a family-based petition is pending?
So that is a very sad and complicated situation. So typically, as long as the petition was filed before the child turned 21 in general, right? Usually there's a statute called the Child Status Protection Act. And depending on the status of the petitioner, so if it was a U.S. citizen, the child's age would be frozen at the time of filing. Okay. Unfortunately, though, if the petitioner is a permanent resident or is a company or some other entity, then the child's age is not frozen, and there's a potential that the child might be, might not be able to get immigration status because they aged out. So it's a complicated. If it's a citizen, it's easier, right? It's frozen, so it doesn't matter. Although you do have to seek to acquire, really it's frozen, so it doesn't matter. But if it's any other relationship, it is a complicated, you have to quantify the amount of time the petition remained pending with the government. Sometimes you can discount and deduct the amount of time that the petition remained pending with the government, and the child might still be eligible for benefits. But if the petition wasn't pending for very long and it was approved right away, then the child, unfortunately, may not be able to be eligible for immigration benefits. So it's very important that you consult with an immigration attorney and they review the petition, the date of filing, how long it was pending with the government, and the petitioner's immigration status at the time of filing.
Okay. All right. Good to know. Can custody arrangements, or time sharing, as we say it in Florida, affect a child's immigration options?
So that's a tricky question. I mean, I think in general, no, but it could have an indirect impact, right? In certain circumstances. I mean, custody is one thing, immigration is another. I'm trying to think of a situation where it would affect it. So, for example, I guess if you're in this situation where we're talking about step-parent, step-child relationship, right? Well, if the custody gives sole custody to the mother and the mother is not giving any, authority or ability for the child to have an ongoing relationship with the step-parent, well, then you can't meet those step-parent-child relationship obligation requirements because they don't have a relationship, and the custody and the divorce ended that relationship completely. It can also happen for, some situations in immigration options where it requires a showing of hardship to the child, the immigrant, U.S. citizen child or something like that. Well, if the immigrant has no relationship with the child, how can we say that there's hardship to the child if the parent is not involved in the child's life? So there are situations where it can affect it. Usually it's separate, but it can have an impact, an indirect impact, I would say usually.
Okay. All right. How do courts handle parenting plans when one parent may need to relocate internationally? So I will answer this. I haven't seen a judge grant, not that I've seen people request to move internationally a lot, but it's the same law that is applied for any sort of relocation. You have to show that the relocation is going to be in the child's best interest. So if there's already a court order for time sharing, and it's, say for an example, a 50-50 time sharing order, and you're trying to relocate anywhere outside of the state, outside of the country, you're going to have to show that why that's going to be in the child's best interest. And so even moving sometimes to California, or Alaska, or to the New York, the judge may not grant it based on the circumstances. If that child has other family here, the other parents here, they have substantial time sharing. So it can be an uphill battle to try to relocate even within the United States. And I haven't personally handled any cases where someone has requested or asked to relocate internationally, but it's going to be the same statute that applies, the same factors, and ultimately it will come down to, is this move going to be in the child's best interest? And so based on that, the courts will examine it, and then they will rule whether or not the child will be allowed to relocate. The parent can always relocate, right? The parent can. The issue is, will the court allow the child to relocate? And so that's going to be based on the circumstances. How much contact will the parent have once the move happens? What are the costs for travel to get the child back and forth from Florida to another country? Like, all those things will be considered. And it's not necessarily.
It sounds like it would be a bigger challenge than the state one, right? I guess that's probably why people don't even ask you, because.
Well, I mean, but I guess it depends on too, like, okay, are you trying to relocate to the Virgin Islands? Are you trying to relocate to, or just say like Puerto Rico, or to, or are you trying to relocate to California? Right. So it's, you have to look at the distance, the costs. You have to look at, all the things. Where do the children, like, does the child have family here? Is it more family there? Like, it's a lot that has to be considered, but.
Sounds like it's something that definitely needs to be addressed with you, and for you to have that full analysis of all those factors, right?
Yeah, it's a lot. It's a lot. It's not easy.
Sounds good.
All right, last question. What happens if we separate before my green card is approved?
So, this is a challenging situation. Separation alone would not affect the green card process, all right? Because it's not a legal termination of the marriage, and you're entitled to the residency status as long as the marriage was entered in good faith at inception. Then you're still entitled to immigration benefits. Now, there's always an issue as to whether the petitioner, because it also is required that the petitioner agree to sign that affidavit of support that we talked about earlier, right? So if the person separates and you're still married, so you're still entitled to the petition to residency, but if the petitioner says, I withdraw my sponsorship, you've got a big problem because you don't have you cannot meet the affidavit of support requirement. But in general, separation alone is insufficient to stop the residency process. Now, once you divorce, it's a big problem, because if you're here as a result of the relationship and the relationship is not there anymore, where they're in general, then you're not entitled to a residency anymore because the marriage ended. If there's extraordinary circumstances like abuse, any type of physical or emotional abuse, then potentially you could do a self-sponsorship. But if there's no extenuating circumstances, then I would say, unfortunately, again, with a divorce, the process ends, and it's technically automatically revoked, the petition, once you divorce. So if your green card has not been approved, it ends. It's terminated automatically when you divorce. But if it's just separation and there's no final divorce proceeding, then the process can go on. But be on the lookout. Make sure your attorney is aware that the petitioner has not withdrawn the sponsorship, the affidavit of support requirement.
All right, got it. Well, thank you so much, Frank, for answering the questions. How can everyone reach out to you if they need have a question or want a consultation? What's the best way for them to reach out to you?
Thanks for having me again, Conti. So they can reach out to us at Symphorien-Saavedra Law, and our phone number is 407-802-1717. We're on social media, on our website. It's a privilege to work with you, Conti, and it's really nice. It makes things so much easier to work with people that are the best at what they do.
And you're board certified, because you're less than 2% of attorneys are board certified in the state of Florida, right?
Well, yeah, but don't be shy. You got a couple of board. You got one. You got one in your office. You've mentored, right? So she's strictly directly as a result of your support and guidance. So congratulations on that, by the way.
No, thank you. We're excited to have Amina. She is board certified in marital and family law, and so she worked really hard, put in all the effort and passed the test. So we're excited to have her join the ranks of the other great board certified attorneys here in Florida.
Is she the only Black female board certified person?
She's the only Black board certified attorney in marital and family law in Orange County.
Nice.
And so we are excited for her to pull it off. She's very smart, very talented, and we're really proud of her. And if anybody has any sort of family law issues, we would love to assist you with those. You can contact our firm at 407-831-0203. And our social media and website information is on this slide as well. So thank you, Frank, for answering the questions. I always learn something when I talk to you. And so if you have any questions at all about immigration, Frank is your guy. His firm is amazing. They do great work. And we don't have any issues with anyone who we refer over to him. So please give him a call. And thank you all for joining us.
Thank you, everyone. Thank you, Conti.